Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, it's not often that we get to spread good news, but guess what? We have some good news from, of all places, the state of New York. Now, for my Washington viewers, we oftentimes sit here and piss and moan all the time about how bad we have it out here in Washington State. But something my dad always told me, and it is very true, is that anytime you think you have it bad, you do not have to look too far to find people who have it far worse. Well, for my Washington residents, do you think it could get worse than us? Oh yes, it could get a lot worse than us. Try living in New York State. Try living in California. Or, election day, try living in the state of Oregon, perhaps. However, despite all of New York State's efforts to continuously keep its citizens disarmed, a very wise judge has put a halt to that. So today, we're going to spend a few really fun minutes and talk about New York gets a gun law beatdown again. Okay, before we get going down the road we're going down real quick, and proud to announce that this video is being brought to you by Legal Heat. That's right, the nation's largest educator of concealed carry classes. Legal Heat has now taught over 200,000 people nationwide since they started business in 2005. Now, for my Washington viewers, you can find classes at any one of these locations right here. If you are watching from somewhere outside the state of Washington, congratulations, you are living far, far freer than we are, unless, of course, you live in the state of New York. However, you too can find classes. All you need to do is visit them at mylegalheat.com. That's mylegalheat.com. Now, listen, for every one of you, no matter where you are, if you find a class and you like it, go ahead and sign up and use the promo code Washington Gun Law. That's Washington Gun Law, all one word, and you will receive 10% off. So for more information, visit them at mylegalheat.com. Okay, so what we need to talk about today, and it's a doozy, and I actually had done a couple of videos, and then just before I could publish them, the appellate courts were changing things up, and everything was moving so fast and furious over there in New York State, I finally said, you know, the hell with it. I'm going to wait until things kind of settle down, and then I'll try to get everyone up to speed. We are talking about New York's Concealed Carry Improvement Act. Now, I'm not sure if New York has a different definition for the word improvement, because this was no improvement whatsoever from what was previously a terrible law. Now, let's go back in our time machine here for a second. Quick little history lesson. As we know, New York, like several other states in this country, had these crazy may issue laws, which means if you wanted to get a concealed carry law, concealed carry license, I should say, you would actually have to apply, and in addition to demonstrating that you're lawfully allowed to possess a firearm, I think a very reasonable request, you also had to demonstrate that you had proper cause or some special need in order to actually carry that firearm. And of course, local governments use that second part of that test, sound familiar, and to just say, well, no, you don't have a special enough need, a proper enough cause, or whatever terminology they were using. And so that's what basically kept New Yorkers from being lawfully armed. Now, obviously, there is no problem with New Yorkers who want to unlawfully arm themselves. I think that we can read the paper every day to figure that out. But for those millions and millions of New York residents who just wanted to obey the law but protect themselves and their family, no, the state got in the way of that. Well, as we know, those rather oppressive laws were challenged to the United States Supreme Court in a case called New York Pistol Rifle Association v. Bruen, which not only overthrew these very draconian may carry laws, not unique to New York though, because New Jersey has them, Maryland has them, California has them, Hawaii has them, so these are not just unique to the state of New York. But not only did it strike that down, it obviously set forth an entire new landscape for how we're going to analyze Second Amendment cases moving forward. However, one of the things that I have begun to learn, the more and more I've geeked out on some of these amazing pieces of litigation that are advancing the causes of the Second Amendment, is that those on the gun-grabbing left are not particularly good losers. No, in fact, they hate losing, and in fact, when they do lose, they oftentimes throw a temper tantrum. Well, then, of course, enter New York Governor Kathy Hochul. Oh, yes. You see, because Governor Hochul and all of her friends in Albany, they absolutely had a tissy fit when the Bruen opinion came out. And so rather than just withdrawing all of these special needs or proper cause things and allowing New Yorkers to lawfully enjoy their Second Amendment rights so they can protect themselves and their family. No. They decided that they needed to do a Concealed Carry Improvement Act. What it really was just a whole new litany of similar or expanded limitations, taking New York's terrible law and making it an absolutely terrible law. And of course, they did away with the proper cause, how magnanimous of it, but what did they do? They replaced it with good moral character. Sound familiar? New Jersey, you guys are kicking the same thing around right now, okay? And so instead of having to demonstrate a special need or proper cause, you now have to demonstrate that you are of good moral character. Now, I've pointed this out before, and I want everyone to wake up to this concept, which is if you have to demonstrate that you're of good moral character, does that mean that the state starts from the presumption that you're a bad moral character and you have to overcome that presumption? Well, Dateline, November 7th, 2022, the Honorable Glenn Suddaby in the Federal District Court in New York has issued a significant, and I do mean significant, injunction against much of New York's new Concealed Carry Improvement Act. Now, just to get you up to speed on what previously had happened, after this law was passed, there was an immediate suit for an injunction filed by the Gun Owners of America and various other plaintiffs, which was granted. However, an appellate court got their hands on it and said, no, we're going to lift that injunction, and so New York got to employ those laws again. However, now Judge Suddaby has struck down significant portions of this law. What is enjoined from being enforced effective immediately in the state of New York? The following: requiring good moral character, requiring the names and contact info of spouses and other adults in the applicant's home, requiring applicants to disclose social media accounts for review, and the restrictions on carrying in public parks, zoos, places of worship, locations where alcohol is served, theaters, banquet halls, conferences, airports and buses, lawful protests or assemblies, and the prohibition on carrying on private property without express consent from the owner. And this injunction takes effect immediately. So by the time you are watching this video, this injunction will already be in effect. And listen, big kudos go out to the Gun Owners of America, who once again, for the 1 millionth time, has jumped out into the trenches, been the named plaintiff on this thing, and absolutely fought the good fight to advance the cause of the Second Amendment. The Gun Owners of America was quoted as saying, just like we warned politicians after the Bruen decision, fall in line or we will force you to. We are excited to see Kathy Hochul finally served a plate of humble pie, and we are fully prepared to continue the fight should she again attempt to disarm the citizens of her state at a time when her party's policies are only escalating the danger that everyday citizens face. And kudos to GOA for also spiking the football in Governor Hochul's face. However, they raise an excellent point, because under Governor Hochul and under the previous regime, there is no question that New York State and New York City has seen a massive and alarming rise in both violent and property crime. There is no doubt that citizens of New York State and New York City are less safe today than they were 2 years ago. And yet, while the local and state governments seem to make the communities less and less safe every single day, they also want to disarm their lawful and responsible citizens. And listen, this must have been a very convincing argument, because as Judge Suddaby was quoted as saying, this law, quote, imposed unprecedented constitutional violations. And that certainly is pretty strong language. Okay, the case once again is Antonyuk versus Hochul, and we will put a link for all of that down below so you can follow the developments on it. Congratulations to the Gun Owners of America for a fight well done. Obviously, there is more ahead, and congratulations to all my viewers in New York State. You get to enjoy your Second Amendment rights a little bit better for at least one more night. In the meantime, if you have any questions about this legislation or anything else related to your Second Amendment rights, remember, you can always contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now, let's remember, part of being a lawful and responsible gun owner, like we talk about all the time at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.